Hi, everyone. Thanks for joining us for this Tech Contracts Academy LinkedIn Live conversation. We are David Tollen and Kathy O'Sullivan. We are colleagues at Tech Contracts Academy and at Sycamore Legal, both of which David founded. Hi, David.
Hi, Kathy.
So our topic today is hard issues in tech indemnities. We expect to go about 20 minutes. Before we dive in, some quick housekeeping. While we're both attorneys, this program's for general information of purposes, not as legal advice. It's also not intended to create an attorney-client relationship. It's also not intended as attorney advertising. Regardless, it's important to recognize that legal situations differ and results depend on the unique law and facts that apply to them. Time permitting, David will address questions at the end. You can submit them using the comments feature. And finally, this conversation is being recorded and will be posted shortly after this on LinkedIn. So with that, let's dive in. David, let's start with some of the most difficult questions surrounding indemnities and then circle back for a broad explanation of why this clause creates so much confusion. First, you've argued that limits of liability don't apply or might not apply to indemnities. Why is that?
Yeah, so this issue gets into some of the fundamental sources of confusion and trouble surrounding indemnities. It's just sort of, right there when you're looking at the limit of liability. Why doesn't this clearly simply apply to the indemnity the way it applies to other clauses? And just to clarify the argument I've made about this before I explain it, I'm not saying that the limit of liability doesn't apply at all to the indemnity, or that it shouldn't. What I'm saying is that the way it applies is generally misunderstood. So people assume that what the limit of liability is going to do is limit the amount of money the indemnitor has to spend under the clause, the money that the indemnitor has to spend defending the indemnified party and paying settlements or judgments to the third party, to the plaintiff in the case. What I'm saying is that it doesn't make a lot of sense, and it is at least not clear that the limit of liability would limit either of those things in any way. That doesn't mean that the limit of liability plays no role if the indemnity is breached. The limit of liability applies to breach of an obligation. So if you breach your obligation to indemnify, your liability for that breach should be limited by the limit of liability. So really the point I'm making is that we imagine that the limit of liability, that $1 million dollar cap, for instance, means we don't have to spend as the indemnitor more than $1 million defending the other party and paying settlements or judgments. And I want to raise the concern that that might not apply at all. That might be entirely wrong, or that might be partly wrong. And so if you are doing contracts where you're the indemnitor, you need to rethink this. You need to think through how this is going to work. So let's look at why am I making this claim? What's the issue? The indemnity in a tech contract, in tech contracts, we use indemnity in a more narrow sense than in some other industries' deals. Almost all tech contracts indemnities are limited to an obligation to defend a third-party lawsuit and pay settlements or judgments to that third party. You can use indemnify, an old common law concept, more broadly for all kinds of obligations and responsibilities. But in tech contracts, it tends to be limited to third-party lawsuits. So the obligation is to defend a third-party lawsuit. That's usually specified, although it could be implied if you just say indemnify. But it's to defend that third-party lawsuit against the other side, like the vendor defending an IP claim against the customer. And it's to pay the settlements or judgments to that third party. So right from the start, that should raise a concern about the application of limit of liability, because at no point have I mentioned a liability to the other party. This is an obligation to hire lawyers and defend a lawsuit and ultimately to pay a settlement or judgment to a third party. That's not what a limit of liability addresses. The limit of liability clause addresses one party's liability for damages to the other party in that contract. So If your obligation is to perform in some way, then the fact that you've got a limit of liability for breach does nothing for you, at least arguably does nothing for you. Your obligation to defend isn't damages. Your obligation to pay a settlement to the third party or pay a judgment to the third party isn't damages, at least to your contracting party. That's the concern. That's the issue that arises here. And this gets it to the heart of why the indemnity is so unusual. The indemnity creates obligations related to dealing with a third party. It doesn't apply simply or in any obvious way to your liabilities or obligations to the other contracting party. So let's look at how this is going to come up in practice and possibly explode in the face of the indemnitor who thought it was creating a limited obligation. Let's say you've got that $1 million limit of liability in your deal, and you have an obligation to indemnify, defend, etc., third-party claims. You spend $1 million in litigation, and maybe let's just say you're just in litigation, you haven't got through the litigation, you've spent $1 million defending the other party, and you say, okay, we're done. The limit of liability now kicks in. We've spent the $1 million. We have no further liability. If your indemnified party is smart, they'll say, oh, no, it doesn't kick in. That's your limit of liability for damages to us for breach. It has nothing to do with the amount of money you have to spend performing, the money you spend hiring lawyers. So you have to keep defending this lawsuit. You're spending $1 million doesn't apply. Doesn't have anything to do with the limit of liability. And there's a good parallel to support that argument, which is, let's say you have an obligation to write software for the other party. That's your obligation under the contract. The fact that there's a $1 million limit of liability doesn't mean $1 million somehow caps how much money you have to spend writing that software. If something goes terribly wrong and it costs you more, nothing about the limit of liability is going to cap your obligation. So if you want to take advantage of the limit of liability at that point, so you've spent $1 million defending this lawsuit, and the other side suddenly tells you got to keep going. The limit of liability has nothing to do with it. What do you need to do? You need to breach. So at the point at which you've breached your obligations under the contract, now the limit of liability kicks in. And so assuming the limit of liability applies to your intentional breach of the contract, now you have a potential additional $1 million liability to the other party. Now the limit of liability kicks in and applies to your damages to your contracting party, to your partner in the contract, resulting from their loss for your breach of contract, whatever money they now have to spend dealing with the third party lawsuit.
Can we explore that a little more, Dave? Because you've pointed out that indemnities don't work well or as expected when they're triggered by the indemnitor's breach or the wrongdoing. Can you explore that some more?
Yeah. So the concern is that the indemnity Well, actually, why don't we come back to that issue, because I want to make sure I finish the point about the application of the limit of liability. The fundamental point is this: the indemnity is in a tech contract is mostly addressing an obligation to perform. You have an obligation to defend the other party. And the limit of liability addresses your damages to your contracting party. And so they're inconsistent. Now, there are common law arguments you could get into. And I kind of feel like we need a research project that at least your obligation to indemnify applies to, does count as damages, that a court could look at that as a form of damages that would be governed by the limit of liability. What I'm saying, though, is we as contract drafters need to avoid that ambiguity. What we need to do is just, if we want the limit of liability to restrict our indemnity obligations, we need to make sure that it actually does. And the way to do that I've offered is very simple. And there's a link in the comments to an article I wrote about this that offers a clause, and it's also in my book, which says essentially, indemnitor is not required to spend more than X dollars pursuant to Section 9, the indemnity, including without limitation on attorney fees, court costs, settlements, judgments, and reimbursement of costs. In other words, instead of relying on a limit of liability that you're uncertain will apply or apply clearly, you just very clearly state that the obligation to spend money defending the other party is capped. Period. End of story. And you get a simple result. All right. So let's turn to your question. It was the issue that indemnities don't work well or work as expected when they're triggered by the indemnitor's breach or their wrongdoing, right?
Yes.
So this is another separate complicated issue surrounding indemnities. And it's an issue that comes up particularly in data indemnities, in indemnities where one party is indemnifying, usually the vendor, but it could be either party, for data breach. Because in those clauses, you very rarely say, we're going to cover all cases about data breach. You generally say, we're only going to cover cases where the indemnitor, have done something wrong. That throws a wrench into the workings of the clause. So the indemnity works best when the two parties are on the same side in potential litigation against a third party. So take the typical example of the IP indemnity. Generally that clause is not written to say that the indemnitor, usually the vendor, is only going to defend the case if it did something wrong, if it actually infringed a third party's intellectual property. What it generally says is if there's a case that falls under certain definition against the indemnified party, the indemnitor is going to defend. Right or wrong. So it's very easy to see how in that indemnity, the two parties are on the same side. They both want to win against the third party. And so this clause, which is kind of fundamentally about the two parties cooperating in a lawsuit against a third party, this clause works well. Now take an indemnity where the indemnity doesn't apply unless the indemnitor did something wrong, like breached its data security obligations. What if the indemnitor denies that it did anything wrong? What if you have the indemnitor and the indemnified party arguing with each other, disagreeing with each other about whether there has been wrongdoing by the indemnitor? In that case, so problem number one, right at the time that ideally you're cooperating against the third party who's suing one of you or maybe both of you, you're actually attacking each other, possibly in open court. Each of you is generating arguments that are useful for the plaintiff. But it actually gets even more complicated than that. So right from the start, the indemnitor is supposed to defend the case against the indemnified party. And you might say, well, this isn't a problem because the court will decide whether the indemnity applies. But that doesn't happen until the end of the case, if you ever get there at all. And the obligation to defend starts at the beginning. So at the point at which the indemnitor is supposed to step forward and start defending the litigation against the indemnified party, there's no decision, there's no authoritative decision on whether the indemnity applies at all. And that's really a problem. So from the indemnitor's point of view, you get there. Do you defend the case? Do you not defend the case? If you don't defend the case, do you give up any possibility of protecting your interests in that litigation so that you don't defend it and there's a lousy settlement or a lousy outcome in the litigation by your indemnified party, and then they sue you under the indemnified part of the clause for that money? You kind of have a mess on your hands. And it gets worse. And it gets worse because of what I call the duty to defend law. In many jurisdictions, the indemnitor is required to defend a case even if it has a bona fide argument that the indemnity doesn't apply. The duty to defend principle in the common law of a lot of jurisdictions just basically says if you've got an indemnity, you're obligated to defend the case at least until you get a court decision on the question of fact surrounding whether the indemnity applies. So you as the contract drafter did a great job limiting your indemnity and saying we're only defending this case if we breached the contract or violated the law or something. And surprise, you find you're actually required to defend the case. This whole problem again gets at this issue I'm talking about, that the logic of this clause is kind of screwy because you're dealing with not just obligations between the two parties, but you're dealing with problems related to a third party. Long story short, the indemnity works really well when the anticipated case is between just the two parties against the third party, and they're likely to be on the same side. And they're on the same side because the indemnity isn't triggered by anybody's wrongdoing. They're not likely to be in a dispute. It's not out of the question, but they're not likely to be in a dispute about whether the indemnity even applies. Whereas when you are in a dispute about whether the indemnity even applies, you get this mess on your hands. You get all these problems. And so if you're a vendor, for instance, of technology, and you're asked for indemnities, for instance, about data or other topics where you think that the indemnity is going to be triggered by your wrongdoing, where that's how the clause is drafted, you should really hesitate about whether to grant that indemnity. And so just before we move on from this question, different solutions, in some cases, you do apply some kind of limit of liability to the indemnity obligation. You limit how much you need to spend. And again, as I said, in answer to Kathy's last question, you want to be very clear that you're limiting your obligation to spend money under the indemnity clause, not just your liability under the indemnity. But all the uncertainties and problems that arise under this situation where the indemnity is triggered by your wrongdoing are at least reduced where you have some kind of cap on liability. Another solution, ironically, is to make the indemnity go both ways. Let's say for a data indemnity, the vendor indemnifies the customer for data breaches caused by the indemnitor's breach of contract, while the customer does the same. It indemnifies the vendor for data breaches caused by the customer's breach of contract. That doesn't simplify the legal issues. It's still a mess on your hands, but now each party is dealing with the same mess. So they're likely to work it out. They're likely to agree, at least for the defense, all right, we'll defend ourselves, you'll defend yourselves, and we'll see what the judgment is at the end. And at that point, one may owe the other for attorney's fees or whatever. So the fact that you share the problem is likely to at least make it easier to manage this issue. And so if you're, again, a vendor being asked for an indemnity that's triggered by your fault, you might say, okay, but if the loss is your fault, customer, you indemnify us. That's another way of handling this very complicated problem.
So Dave, you've touched a bit on IP indemnities and data indemnities, and those tend to be the most heavily negotiated in the world of indemnities. Is there anything else you'd like to add specifically about those in tech contracts?
Yeah, I mean, it's helpful to look again at how those two illustrate the problem that I just explained. In an IP indemnity, again, you usually don't say the indemnity is triggered by the vendor's wrongdoing. It's breach of contract. It's infringement of third-party IP. You just say if there's a claim about the vendor's technology, the vendor is going to defend the customer. There's obviously some restrictions and limits to that, but generally it's not a claim that's triggered by whether the vendor is in the right or the wrong, but rather just by whether there's the third-party claimant has made a claim against an intellectual property claim related to the vendor's product. So you largely eliminate the problem I just talked about because, again, there's no dispute necessary about whether the vendor did anything wrong. And so the two parties are going to be on the same side. Now look at the data indemnity. In a data indemnity, no way the vendor is going to agree to cover any claim, say, about a data leak from its own computers. They're just not going to do that because they know the customer could cause it. And so this problem does arise. And that's one of the reasons it's harder usually to get the data indemnity done. IP indemnity is very standard. But in a lot of deals, the vendor either won't give a data indemnity or gives a very restricted data indemnity. Sometimes it's because the vendor just, has a gut instinct, this is a bad idea. Other times it's because the vendor understands this problem and what a mess it's going to get into in the data indemnity. The one final thought I'll leave for customers on this issue is, don't fall into the trap of thinking that because you didn't get an indemnity about data breach, that the vendor has no liability for it. This is just about defending third-party claims. Your vendor could still be liable to you under, an extensive data management and security clause. If it breached those terms, it has, damages to you. This is not about a third party. So don't imagine that you have no protection for data breach if you can't get a data indemnity.
So just stepping back from the details, of which there are many, why is this so hard? I mean, this is a heavily negotiated clause. It leads to tense negotiations. Why is it so often that it works contrary to what people expect?
Yeah, it is hard. And if you're listening to this talk and feeling this moved quickly or this was confusing, don't feel bad. I think this is the hardest set of issues in technology contracts. And luckily this recording will be online and you can listen to it again. And we're going to talk at the end about some resources for more information on this. But I think the answer to the question is this is so hard is because we're bringing in obligations related to a dispute with a third party. Most contract terms just regulate the relationship between customer and vendor, between the two parties to the contract. And all of our thinking is sort of geared around that relationship. What's the relationship between these two parties and when could one be liable to the other? When you look at an indemnity, you throw a wrench into all of our logic. And if you're not very aware of that fact, you're going to misunderstand the clause, because it sounds like the indemnity is talking about liability to a third party, and it uses similar terms for its liability to the other contracting party. So you're throwing in responsibilities and liabilities to a third party. And when you do, you got to really think, well, how do terms of this contract that relate to the relationship between us two apply to obligations pointed at that third party? And it's our failure to ask that question and failure to really think it through that I think creates so much confusion. And our experience, I think Kathy's is the same as mine, in negotiating this clause is that it tends to be very heavily negotiated, and very often part of the battle is that the two sides have different assumptions about what it all means. They think the indemnity clause, they don't agree on what the terms mean because one or both doesn't really understand it. Obviously, it's much harder to negotiate and reach agreement if you're not speaking the same language, if you have different assumptions. Let me throw in a final thought before we move to a sort of wrap-up question. We've talked about indemnities, assuming that you're using the typical formula, defend and indemnify the other party. What if you leave the word indemnify out of the clause altogether? This is called a settle and pay obligation. Instead of using the word indemnify, you say, vendor is going to defend any claim about X, Y, and Z, pay any settlements, pay any judgments, and you never use the word indemnify. I think in a way you sort of, you arguably clarify the obligation and also highlight the problem I'm talking about. Indemnify, that word is where you get the suggestion that we're talking about creating liabilities. When you just describe it as an obligation to defend a lawsuit and pay a third party off, it becomes very clear that this is a clause about performance, not liability. This is a clause about obligations that have nothing to do with damages. In a way, that could clarify it. And some companies say we're not going to use the word indemnify in our indemnities. We're only going to describe the underlying obligations, defend the case, pay a settlement, pay a judgment. It may be that if you use that language, some of the confusion around this clause will be at least a little bit reduced, because it'd be clear that you're talking about obligations that point toward a third party, not damages between the two parties.
Well, shockingly, we seem to have run a bit long. We do have plenty of questions. Would you like to address any questions before we move on?
I think what I'm going to do is offer answers to the questions in the comments and offer some further thoughts. But it would be helpful to point out where you can learn more in addition to that. So first of all, there are 2 articles that I've posted in the comments on the first issue on why limits of liability. Actually, the first one is on why limits of liability don't work for indemnities, or at least arguably don't. And it offers the better solution, a limit on indemnity obligations. It offers text for you. So that article is posted there with a link. And then there's a separate article that's related, a little bit less central to what we've discussed here today, which is the question, should the limit of liability or a limit on indemnity obligations apply to the indemnity at all? In a lot of cases, the indemnified party argues there should be no limit. It doesn't make sense. And that other article addresses that. The large, very difficult, very complex issues that we're talking about with indemnities, other places to go. So first of all, our Tech Contracts Masterclass, the third of the 4 classes in the series, covers this in detail. And we go into these very hard issues. And obviously, we would love for you to take our masterclass anyway. And we have a series starting again in January, starting on January 10. And this is incidentally on time for CLE. If you're a California lawyer, it gets all done in January before your deadline. But anyway, available to everyone. We go into this in some detail and wrestle with this. Also, my book does, the Tech Contracts Handbook, the 3rd edition. There's a chapter on indemnities. It addresses all of these issues that we've talked about. So does the chapter on limit of liability, but particularly the chapter on indemnities. And subchapter 5 of the indemnities chapter addresses this most complicated issue, which I call the cause problem. This issue of of how the indemnity works when it's triggered by somebody's wrongdoing, when the indemnitor's wrongdoing is what triggers the indemnity. So that also is available to you. But as I said, I will answer questions in the comments, and I very much appreciate you participating with us today. Other articles we've posted on this and on LinkedIn have led to lengthy discussions in the comments and not a few complaints like, this can't be true. That's great. Let's have that discussion. I think it's great to have, and it's, in the end, if we all just think through these very hard issues in this very hardest clause, I think we'll do a better job in our work. Thank you very much.
Thank you. Great talking to you.
You too.
If you found this video useful, please come check out Tech Contracts Academy. We provide training on drafting and negotiating contracts about artificial intelligence, cloud computing, and other forms of software. It's all for lawyers, contract managers, and any business people involved with contracts. So please come check out our programs live and on demand at techcontracts.com.